sir. These are all the members.
Yeah, this is one team. Two teams.
No, these are two teams, two people. One, two, and the others. Sir, as they will speak, you can see, you will be able to see them on the screen. All right. I'll be here in the room if there is any issue. All right. Sir, the earphone is yours.
Team 39, can you just give your time?
So he happens to be promoter. He is the
court master.
Court master.
Team 39, can you please give your time division? Speaker 1 seems like she's having some internet issue. Team 39. Okay. Speaker 1 will rejoin.
Let us start.
Sir, speaker 1 from team 39 will rejoin in 1 minute, sir.
So, team 39 speaker 1 will be taking 20 minutes. Speaker 2 will be taking 15 minutes and
15 minutes.
Yes, sir.
Okay.
And the rest will be reserved for rebuttals.
Got it. Sir, please.
Should the appellants begin?
Yes, firstly, introduce yourself.
Indeed.
What is your name? Good name?
My good name, the OC, may I please reveal my name to the Honorable Bench?
Yes.
Indeed. My name is Dakshita Dubey. I'm presenting as the first counsel from the side appellant today, that is Raghav's. My co-counsel, her name is Udi Prakash. She'll be the second counsel from the side appellant. We are team code DL071. May we please begin?
Yes, start.
The council seeks permission to address the bench collectively as your lordship. Much obliged, your lordship. Greetings, your lordship. This is the first counsel from the side appellant. The counsel shall be taking 40 minutes of the court's precious time, 18 by the first counsel, 20 by my co-counsel, and shall respectfully reserve 2 minutes for rejoinder. The first counsel shall be dealing with the first 3 issues that deal with the issue of maintainability of the present petition, whether the appellant is guilty of the offense of criminal intimidation, and whether the prosecutrix and the complainant are credible witnesses. Whereas my co-counsel shall be dealing with the issues of medical evidence present, as well as whether or not the appellant is guilty of the offense of rape. If your lordship are well versed with the facts of the case, the counsel would like to proceed with the first issue.
Yes.
Much obliged, your lordship. Your lordship, the first issue deals with whether the present petition is maintainable or not. Your lordship, Article 136 of the Constitution states that the Supreme Court may, in its discretion, grant special leave to appeal from any judgment, decree, determination, sentence, or order in any cause or matter passed or made by any court or tribunal in the territory of India. It has been further held, your lordship, in the case of Surajpal Singh versus State of Uttar Pradesh, citation number 4, your lordship, the accused in a criminal case must be given the benefit of every reasonable doubt, and therefore, when he offers a reasonable explanation of his conduct, that explanation should ordinarily be accepted unless conclusively proved otherwise. Furthermore, in the case of...
One thing. We are aware about the provision, Article 136.
Indeed.
It is a case of concurrent fighting by the trial court as well as high court.
Indeed.
Now, in order to make a case for special, maintain your case under Section 136, you must have a very strong case.
Indeed.
What are the grounds on which you want to challenge this the judgment?
Indeed, your lordship. Your Lordship, you're very correct in describing what a special leave petition and what the grounds are for a special leave petition. The same
How
as
you can say that the judgment, the finding of facts are perverse in nature?
indeed, indeed, Your Lordship. Your Lordship, the same has also been held in the case of Matru versus State of UP. What the Honorable Lordship has just stated, that in case of miscarriage of justice, the court grants special leave. In the present case, Your Lordship, there is no concrete evidence that incriminates the appellant, thus failing to prove the guilt of the appellant beyond reasonable doubt, which the counsel seeks to prove through the course of their submissions via this special leave petition. For example, Your Lordship, the sole testimony of the prosecutrix is not a credible one. That is, the prosecutrix is not a sterling witness, which is why it needs to be corroborated by the evidence on record present. When it is not corroborated by the evidence on record present, it fails to prove the guilt of the appellant, and therefore the appellant cannot be convicted of these said offences. Your Lordship, if you are satisfied with the first issue.
On what grounds or on what points you are saying that the prosecuting is not a credible?
Indeed, indeed, Your Lordship. Your Lordship, the point
Actually,
that
one thing you must it must be kept in your mind that according to your defense case, the accused was present on the spot.
indeed,
Something happened on that date.
indeed,
Now,
Your Lordship.
keeping the defense in your mind, you have to say on what grounds you are saying that the prosecuting is not a credible.
Indeed. Indeed, Your Lordship. Your Lordship, the answer to your question lies in my third issue, which I'll be coming to directly. The third issue deals with that there are material contradictions in the statement of the prosecutrix, which makes her unreliable.
No, just a minute. What is relevancy of statement recorded under section 313 of the CRPC?
Your Lordship,
And if you have admitted your presence in a statement under section 313 CRPC,
indeed,
then to what extent it has got adverse impact upon your case and supporting the case of the prosecution. So in the aforesaid background, coupled with the fact that that there happens to be concurrent finding of the learned court below, what you have a special ground,
indeed,
in this case, to have the case admitted and in likewise manner
indeed, Your Lordship. Indeed.
to have the appeal allowed, setting aside the concurrent finding of the learned lower court.
Indeed, Your Lordship. Indeed.
And one thing more. I'm sorry to interrupt.
No, Your Ladyship.
Just answer the question with regard to the presumption that is being granted under 114A of the Evidence Act.
Indeed, Your Ladyship.
Which talks about the presumption as to the absence of the, as to the consent of the prosecutrix.
Indeed, Your Lordship. Your Ladyship, I believe.
Then in that regard, Madam, I would like to draw your attention towards the status of the victim. She happens to be minor. She happens to be minor. Then in that circumstance, whether she had consented or not, that has got
no relevance in this case. Her consent is not a relevant fact in this case.
That is
because she is minor.
So two things are relevant. That is, you have shown your presence. You have not only your presence, but the presence of the victim at the spot.
Indeed, Your Lordship.
That is, you should have taken a negative, the denial, complete denial. That yes, the articles were not put on PI parade. It were not. The police has not cared to get it properly accustomed to know about the whether these pants and gamcha was belonging to the accused or not. Those things were, if there would have been complete denial at your end, then the circumstances would have been something different. When you have not admitted your presence, rather admitted the presence of the victim, then in that circumstance, being the status of the victim minor, though at the verge of majority, then you will have to explain those circumstances and in the portrait background, whether the case of intimidation or rape, those things are there. Intimidation is after the commission of the rape. So those things are there. Kindly go through the same and then argue.
Indeed, Your Lordship. Indeed. Your Lordship, I believe that there have been a lot of parts to the questions of the Honorable Bench. I'll go through them one by one. The first one being, how is the Council stating that there are material contradictions in the statement of the prosecutrix?
No, I'm less concerned. I'm less concerned. I will not go. I will not insist on that very aspect.
Indeed.
I want to know what will be the impact of your admission in a statement recorded under section 313 of the CRPC.
Indeed, Your Lordship. Your
Okay.
Lordship,
when you have admitted your presence at that very moment, at that very place, then in that circumstance, what more the prosecution was required to prove?
Indeed, Your Lordship. Your Lordship, Section 313 of the CRPC gives the power to examine the accused. However, Your Lordship, according to even after the examination of the accused, in which he truthfully admitted that he was present at the site of the claimed alleged incident. However, Your Lordship, it is the appellant's contention that no sexual intercourse or no sexual action has taken place between the two parties. The appellant was present there. The appellant went there because both the parties had romantic relations between them. However, after reaching the spot, when the prosecutrix started screaming, the appellant had to run from that place, leaving only his clothes behind, Your Lordship. Your Lordship, the mere presence of the appellant at the site of the incident without any corroborative medical evidence to support the same. Your Lordship, it is an established fact that no spermatozoa was found on any of the clothes or or on any side of the incident. This proves, Your Lordship, that mere presence of the accused at the site does not prove that sexual intercourse has occurred. Your Lordship, furthermore, the specific issue of evidence as well as of rape and what are the criteria required will be dealt by my co-counsel. The next submission that will come, Your Lordship, will be my co-counsel will be the perfect person to answer these questions.
No, then in that criminal intimidation, the act of criminal intimidation is not before commission of rape. Rather, it was after commission of rape. So whether there happens to be an allegation of the criminal intimidation before the commission of rape, not at all.
Indeed, Your Lordship. However, Your Lordship, even the act of criminal intimidation has been alleged for both. One incident is prior to the incident of rape, and the second one is during the course of rape, Your Lordship.
After commission of rape.
Indeed, Your Lordship. After the commission of rape, as well as prior to the commission of rape, there are two instances, Your Lordship.
Whether charge has I have not. I have gone through your brief. I have not come across with the fact whether charge has been framed for earlier occurrence or not. If charge has not been framed, then it will be a futile attempt to argue on that very score. So I have not found the charge whether charge has been framed for earlier occurrence or not.
Indeed, Your Lordship. Your Lordship, in the Moot proposition, it is merely written that the accused is guilty under section 506 of the IPC.
So it was for subsequent act or before act.
Indeed, Your Lordship, that is the problem of the Moot proposition, and as well as in the case of the prosecution, they have not specified on which act are they contending their case on. The entire case of the prosecution is built on mere vague statements, which they have not specifically stated that which is the statement they want the accused to be accused of the offense of criminal intimidation. Even the statements that have been made by the witnesses and the prosecutrix have included statements like there will be dire consequences if the prosecutrix does not agree to the appellant side. The term dire consequences, Your Lordship, is an extremely vague one. Your Lordship, mere vague threats cannot be considered criminal intimidation. It was held in the case of Shri Padma Mohan Jamatiya versus Shri Jharna Das Bedia that the mere use of abusive words, filthy language, and body posture is not included within the ambit of the provisions of criminal intimidation under the Indian Penal Code. Further, Your Lordship, regarding criminal intimidation, to whom it was intended, whether alarm was caused, and if so, what are the actual words employed are not stated either in the complaint or in the depositions. In the absence of these averments touching the ingredients, Your Lordship, mere mentioning of sections and putting a face to the trial is nothing but the abuse of the process of the Honorable Court. This was also held in the case of Dr. Subramaniam Swamy versus C. Pushparaj III.
Now see, two things are there.
Indeed, Your Lordship.
One thing is where, in a case where simple case of criminal intimidation,
Indeed.
that has got independent identity.
Indeed.
But if the criminal intimidation is during course of major offense,
Indeed.
and that is found substantiated,
Indeed.
then in that circumstance, what will be the effect? What you have cited at the present moment, the judicial pronouncement,
Indeed.
that does not deal.
Indeed, Your Lordship.
So major, in continuation of commission of major offense, if something is uttered, what impact it will have?
Indeed, Your Lordship.
And more particularly when you have succeeded in completing the major offense.
Indeed. Indeed, Your Lordship. Your Lordship, it is very important for us to mention here from the appellant side, Your Lordship, that even in the complaint of the prosecutrix, she has not clearly named the appellant, Your Lordship. She has never confidently stated that it was the appellant who has committed the offense of rape on her. Your Lordship, even in the statement when she said that that she was threatened, that she was being threatened during the course of the incident or even after the course of the incident.
No, I'm coming to that score. Just now, my sister colleague has argued, has asked for 114A.
Indeed. Evidence Act.
Mrs. Fouzia. The thing is, the girl is mine, or at the verge of majority. She was a consenting party. Admitting whether you have suggested during course of evidence that you were a consenting party, that apart, you have admitted your presence along with presence of that victim.
Indeed.
So in the background, in that background, you have, irrespective of the fact that victim has kept silence.
Indeed.
That speaks a lot with regard to intimate relationship amongst both.
Indeed.
But whether on that very score, considering the status of the victim, and further during course of evidence, she denied her involvement with the accused, then accused appellant. Then in that circumstance, without having suggestion at your end, that yes, you at the verge of majority was fully grown up and was fully competent to give consent.
Indeed.
And that was voluntarily at your end, which you gave at an earlier occasion and continued with the same. So those things I'm lacking from the brief. What you have answered on there.
Indeed, indeed, Your Lordship. Your Lordship, regarding the age of... May I proceed, Your Lordship?
Personally, one thing I will ask you.
Indeed.
To concentrate. Firstly, you have to satisfy that this case under Article 136 is maintainable. What are the incriminating evidence or circumstance or ground on which the concurrent finding of fact given by the courts below can be unsettled? Merely saying that the victim has given inconsistent evidence on the points which are almost admitted.
Indeed.
On which points do you want to challenge the credibility of the victim?
Indeed. Indeed, Your Lordship. Indeed. Yes. Much obliged, Your Lordship. Your Lordship, if I may, I'll answer the questions in parts. The first one being the age of the prosecutrix as a question, whether she's a minor, whether she's a major, whether she's above 18 or whether she's below 18. Your Lordship, It is imperative to mention here that in the case of the prosecution, even the age is not is not clear. There's not even a clarity on age. Even the concept of age comes under
matriculation certificate is there, and that is age of the victim is kindly see paragraph
17 years 8 months. 17 years and 8 months.
No, the kindly see paragraph 1 of the background of the case. As per matriculation certificate, the date of birth of victim is 1/1/2002.
Indeed, your lordship. However, after the radiological test, we see.
No, sorry. If you see the case of Jarnail Singh versus State of Haryana and so many other decisions, you have to perform if you contest, if you challenge the status of the victim, then in that circumstance the court has to adopt the procedure as prescribed under the Juvenile Justice Act, and in that act the matriculation certificate has got priority with regard to others.
Indeed, your lordship. However, your lordship, it was also held in the case of Vishnu versus State of Maharashtra that it is common knowledge that parents furnish incorrect date of birth on school or to the school authorities to make up the age in order to secure admission in school. Furthermore, when there was a conflict between a documentary evidence and a radiological test after Jarnail Singh, your lordship, in the case of Prakash versus State of Rajasthan, it was held that the opinion of the medical experts based on X-ray and ossification test will have to be given precedence over the shaky evidence based on school records. Your lordship, because of such judgments, your lordship, we are contending that there is not clarity on the age of the prosecutrix. We're not contending that this is the date of the prosecutrix, and we're not giving a particular date to the honorable court. However, we are contending that there is not clarity on the date of the prosecutrix. There's no the date of the prosecutrix creates reasonable doubt whether she's a minor, whether she's a major. This has also not been dealt in the prosecution's case in the subordinate courts of both the honorable trial court as well as the honorable high court. Therefore, your lordship, the question of age is a question which creates reasonable doubt in the case of the prosecution, because the age factor itself is not being corrected nor being concluded at a conclusive and clear stage in the case of prosecution. Thereby, your lordship, we must acknowledge that in India there are cases where date of birth is changed so that the admission in schools is done in an easier way. We cannot ignore this fact, your lordship. If your lordship are well satisfied with this answer, I'll move on to the next question. May I proceed, your lordship?
No.
Much obliged, your lordship. Secondly, your lordship, coming to the material contradictions and infirmities and inconsistencies that cannot be relied upon, your lordship. Your lordship, it is settled law that if the prosecutrix makes improvements on material points and her testimony suffers from infirmities and inconsistencies, the same cannot be relied upon. This was also held in the case of Suresh N. Bhusare and others versus the State of Maharashtra, citation number 25. Your lordship, where evidence of the prosecutrix is found suffering from serious infirmities and inconsistencies with other material
what are those inconsistencies?
Indeed, your lordship. Your lordship, I'll refer to the Moot proposition itself, your lordship. In the Moot proposition, the prosecutrix is seen making two statements. The first one under section 161 of the CRPC, that is made to the police. In this statement, your lordship, we see that the prosecutrix alleges that there was an incident of rape prior to the month of August 2019, for which we are present here today. She alleges that there had been another incident in the month of May 2019.
The prior incident is not an issue in this case.
Indeed.
Charge has not been claimed about that.
Indeed, your lordship.
Charge has been claimed about the present.
Indeed.
Whether Fouzia omnibus is not applicable in India. We are not concerned whether any rape was committed with the victim at any prior stage. We are concerned with the fact that on the alleged date of occurrence, alleged time of occurrence, the rape was committed with the victim. Hence, if there is improvement or something false has been stated by the victim, how it will affect the validity of the victim in the present.
Indeed, Your
The
Lordship.
charge has been said about the alleged occurrence, date, time, and place of it.
Indeed.
Previous के विषय में, if there is any contradiction, it will be not so. On its basis, the statement of victim cannot be brushed aside.
Indeed, indeed, Your Lordship. Your Lordship, under Section 161, it is the evidentiary value that Section 161 holds is not reliable in the court of law. For this purpose, Section 164 of CRPC is there, which is why under Section 164, the same statement has to be repeated in front of a judicial magistrate. Your Lordship, you are extremely right that a previous case of rape cannot determine the current case of rape. However, Your Lordship.
Now, see, sorry. Recorded under Section 4 CRPC is relevant.
Your Lordship, you're not audible.
Could be. Whether a statement under Section 164 CRPC is admissible during course of trial.
Indeed, Your Lordship.
Whether a statement under Section 164 CRPC, 164 CRPC.
Indeed, Your Lordship. It is made in front of a judicial magistrate, Your Lordship.
I am less concerned. I am concerned whether that a statement is admissible in the eye of law during course of trial.
Your Lordship, it can be used to prove contradictions in the statement of the person making it. For example, in the present case, when you make a statement under Section 161 and it is compared to the statement that you've made under Section 164, and if there are contradictions in the same, the two statements are used to prove contradictions. The evidentiary value they hold is not present. However, they can be used to prove contradictions in the statement. And Your Lordship, you are extremely right that a previous case of rape cannot determine the present case of rape. However, Your Lordship, both the incidents have been talked about in the same statement. The same statement includes a statement which is extremely false, fabricated, of an offense, of a heinous offense. And Your Lordship, the same statement alleges that another heinous offense has taken place. Your Lordship, all the appellant tries to prove here is that there is reasonable doubt in the statement of the prosecutrix, that the prosecutrix is not a sterling witness and her statement cannot be taken on prima facie value as a confident witness. When there is reasonable doubt, Your Lordship, in the statement of a prosecutrix, it is subjected to the evidence on record present and it is corroborated with that. However, Your Lordship, as my co-counsel shall prove in her forthcoming issues, that the evidence on record present is not corroborative of the statement of the prosecutor. If Your Lordship asks,
why the statement of prosecutrix should not be relied upon? Is there any strong ground? Because there is consistent finding of concurrent finding of fact by the lower court. What is the except there you have referred that 161 she has stated that earlier there was a rape.
Indeed.
And subsequently she has said that it was not. Except it, is there any other inconsistency consistency in the evidence of prosecution?
Indeed, Your Lordship. Your Lordship, in the statement of the prosecutrix, if we read the whole statement in totality, paragraph number 11 of the Moot proposition contains her verbatim statement, Your Lordship. In that statement, Your Lordship, the prosecutrix has never confidently stated that it was the appellant who has committed the offense against her. Number one, Your Lordship, that she has always said that she suspected that the appellant was Raghav. She has not confidently herself stated that the appellant was Raghav. Number two, Your Lordship, the prosecutrix alleges that someone held me from back, shut my mouth, and dragged me to Sarpat. Your Lordship, Sarpat is the grass that grows near a riverbed, and Sarpat is known to be to have extremely sharp blades. Your Lordship, one touch of the Sarpat can cause a scratch to the hand. Your Lordship, when the prosecutrix alleges that she has been dragged from the back and that she has been taken to a Sarpat, Your Lordship, it is extremely logical to assume that there must be some sort of an external injury or there must be some sort of a resistance. A prudent man, when held from back, shows resistance, Your Lordship, which could cause some sort of injury. I'm not talking about any internal injury or injury on private parts, Your Lordship. I'm talking about
how many days after? how many days after the occurrence she was medically examined?
Indeed, Your Lordship. Your Lordship,
So you are expecting injury after such long duration.
Your Lordship, in external injury has proven to be stayed.
So how many external injury? How many days? 10 or 12 days after the occurrence.
14 days.
14 days. So after 14 days, what kind of injury? Whether it was bruise or a scratch or something more than that.
Indeed, Your Lordship. However, there was no injury. There was no injury found. Your Lordship, in my co-counsel's issue, she is dealing with the amount of time that is required. From what our submissions hold, Your Lordship, there's a period of around 16 to 20 days for a normal wound on the body to heal, Your Lordship. And even after she is going after 14 days, she was after 14 days she filed an FIR, and after 16 days she went for a complete medical and after 15 days she went for a complete medical checkup, Your Lordship. However, there was no injury found on her body, there was no injury found on her private parts, or there was no internal injury as well. Your Lordship, the point of injuries shall be dealt in extreme detail by my co-counsel, Your Lordship. Your Lordship, if you may permit me, I'll move on to my last submission and then I'll hand over to my co-counsel so that she may answer all the questions regarding medical evidence.
What is, just a moment, what is your submission with regard to the corroboration of evidence by PW4 Jang Bahadur?
Indeed, Your Lordship. Your Lordship.
Because the presence of the accused is found by Jang Bahadur, and he has stated that he has found the accused at the place of incident in a naked, running in a naked condition. So the evidence of prosecutrix, even if there are minor contradictions and minor omissions in the statement, then to her evidence is corroborated by the evidence of PW4.
Indeed.
So what is your submission with regard to the presence of accused on that place of incident?
Indeed, Your Lordship. Your Lordship, as stated earlier, the mere presence of the accused does not determine that that sexual intercourse has taken place. The appellant is contending that the accused was present there, as per the statement of the accused also, Your Lordship, that the prosecutrix had called him to the fields that day, and when she started shouting, he left that place running in that condition, Your Lordship. And that is what is Jang Bahadur testifying to also, Your Lordship.
Then a question arises, if the prosecutrix herself had called the accused there in order to personally implicate him in such a case, then what prevented her to name the accused specifically in FIR?
Indeed.
This circumstance shows that your story, the story of accused, that prosecutrix herself called him is incorrect. Or else, if there was any intention to the victim to personally implicate the accused by calling her at a lonely place, in such a case, due to property dispute or anything, then there would not have been any delay of 10 days or 14 days. Then there would not have been any mention that the accused was not fully identified. The accused would have been named specifically. Such and such person has committed the occurrence. So the defense story does not appear to be correct that the victim called him there. This circumstance shows that the victim was not intending to personally implicate him.
Indeed.
And the statement of accused under section 313 that he was present on this spot at that point of time, corroborated with the statement of this Jang Bahadur, rules out any possibility that the occurrence was committed anybody else.
Indeed, yes. Your Lordship. Your Lordship, the answer to your question would be, I believe that the prosecutrix is not confirmed and is not stating the appellant's name conclusively. Could be because there is existing family enmity between both the parties, and perhaps she's not sure of actually perhaps she's not sure that she actually wants to register a complaint, maybe because it's false. Because, Your Lordship, it was held in the case of Ghanchi Vora Samdushi Isabai versus State of Gujarat that the court is aware that nowadays false charges of rape are not uncommon. And there have also rather been instances where parents have persuaded a gullible or obedient daughter to make false charge of rape, either to take revenge or due to previous enmity, or in this case, due to the pending property dispute between both the parties in the Lucknow Civil Court. Your Lordship, the evidence on record shows that there was previous enmity between the accused and the family members of the prosecutrix, which creates doubt to the truthfulness of the testimony. Again, Your Lordship, the appellant's stand here today is that there is a ground for reasonable doubt in the testimony of the prosecutrix, thereby a conviction based on the sole testimony of the prosecutrix is not a fair one, Your Lordship. Your Lordship, with this, I have completed all of my issues. And if Your Lordship permit, I'll be inviting my co-counsel to make her case. It was a pleasure pleading before the Honorable Bench, Your Lordship.
Prakash, the co-counsel.
Indeed, indeed. Co-counsel, if you could please start.
Greetings. Permission to address the bench as Your Lordships.
Yes.
Am I audible?
Yes, yes, audible.
Greetings, Your Lordships. Your Lordship, Council will be taking 20 minutes of the court's precious time, and the Council will be dealing with majorly two issues: whether the evidence present in record are conclusive in nature, and fifth, whether the act of rape has actually happened, and whether the accused is guilty of the offense of rape. Starting with my first issue, whether
Now,
the
now
evidence...
see.
Indeed, Your Lordship.
Section 313 subclause 4.
Indeed, Your Lordship.
Have you gone through?
I have the bare act, Your Lordship.
Kindly go through this.
Indeed, Your Lordship. The answers given by the section 313 subclause 4, the answers given by the accused may be taken into consideration in such inquiry or trial and put in evidence for or against him in any inquiry into or trial for any other offense which such answer may lead to show he has committed.
That is. So, the question is, the allegation against you is that while victim had gone to ease herself near by the side of the Gomti, then you caught hold her, dragged her, took her to Sarpat field, and then committed rape. And during course thereof, you have given a threat of dire consequence in case you raise halla. That
Indeed.
is the case.
Indeed, Your Lordship.
That. So you have admitted your presence at the by the side of Gomti.
Indeed, Your Lordship.
You have admitted presence of victim
Indeed, Your Lordship.
by the side of Gomti. You have admitted presence at such hour. So hour is also relevant. The time is also relevant. So at that very moment, you were present there.
Indeed, Your Lordship.
So even excluding all the evidences, having on the record brought up on behalf of prosecution, there happens to be no ambiguity with your own defense with regard to your presence at the site with the victim. The only controversy is whether rape has been committed or not.
One more thing, he has also admitted that he fled away from his spot.
That is living behind pant and toli.
Yeah, that. It
So-
is also admitted that he was there without, he has put up his pants there.
So under a forced circumstance, you are expected to explain
Indeed, Your Lordship.
the limited scope having before you,
Indeed, Your Lordship.
whether you are to be liable for rape and criminal intimidation or not.
Indeed, Your Lordship. So, Your Lordship, the contention, as you very well said, is not whether the accused was there or not at the said time, because the accused in his statement himself is saying that he was there. She called her and he went to meet her. When he himself took his clothes off, she started screaming and he fled away. That is the story of the appellant, and that is the story that we are here to defend. Now, Your Lordship, the contention and the ambiguity is whether the act of sexual intercourse has happened or not, and to what extent can the court rely on the statement of the prosecutrix. The prosecutrix says that I was dragged into the sarpat, I was committed the act of rape on, and in the middle of it, I started weeping, screaming. He intimidated me, criminally intimidated me that you will face dire consequences. And when he got scared, he left. It cannot be corroborated by the statement of the witness cannot be corroborated by any other evidence present on record, because there is no injury on the body, there is no injury on the private part, there is no injury which could, if it would have been present because of the act of the rape, it could have been detected after 14 days, after a span of 14 days. The studies have actually showed that after in a span of from a span of 30 minutes to 17 days, the semen can be present in the private part of the woman, and it can be detected. That is, and in the medical evidence, there is no internal injury, there is no external injury. With that, to a very reasonable extent, the story of the prosecutrix cannot be believed with. Now, that is the story of the prosecutrix that cannot be relied on. The story of the accused is that I was there, I took my clothes off, but nothing happened, and I ran away. And that is what every other evidence present on record is actually supporting in the case.
No. Two things are there.
Indeed, Your Lordship.
One thing is, there happens to be a basic theory of criminal jurisprudence. Enmity is a double-edged sword.
Indeed, Your Lordship.
Now, it may be a cause for false implication. It may be a motive for commission of an offence.
Indeed, Your Lordship.
That is, so far rape cases are concerned, it has got no motive. In the aforesaid background, would the court believe the story propounded by the accused side that being on an inimical term, the victim was carrying some intimate relationship or some soft corner with the accused? Was it possible?
Indeed, Your Lordship.
You have pleaded that victim had called me. So was it possible, a feasible one, that yes, in the background of a aforesaid strained relationship, the victim was carrying soft corner towards accused, and under such circumstance she called him and
Indeed, Your Lordship, but the council found it imperative to point out that the enmity was between the families of the appellant and the prosecutrix. The enmity was not between these two particular parties. Secondly, even though the moot prop is silent on the issue, but not once in the moot prop it is said, even if citing the previous incidences, that the prosecutrix herself, by her own volition, out of her own will, has told the accused to repel, to go away and to not do something. Is the only part where it says that he was ridiculed was by the mother, where the mother says that she thinks that he had an evil eye on her, and she is the one who ridiculed him in the first place. So the possibility that the romance and some kind of relationship or any kind of connection between the appellant and the accused and the prosecutrix was present cannot be ruled out in the present case, because there is no substantial evidence that says that the prosecutrix herself did not actually have the feelings for the accused, and she did not actually have any kind of relation. The only problem here is, the only thing that kind of supports this possibility is the fact that their families have an enmity, and the mother did not like the guy, and the mother had thought that he had an evil eye on her, and that's the volition and that's the opinion of the mother in the present case. The opinion of the prosecutrix is not being mentioned in the moot proposition, and the possibility that there might be some kind of romance going on between the two cannot be ruled out in the present case, Your Lordship.
But even if she is a consenting party to that, but taking into consideration her age, her consent is immaterial.
Your
So if you
Lordship,
are accepting this part that she is having a romantic relationship with the accused, then taking into consideration the age of the prosecutrix, even if she has consented and she has called the accused to that particular place and his presence is proved by the other witnesses, then also her consent has no role to play.
indeed,
Even
Your
if she
Lordship.
has given consent for that, it is immaterial.
Okay, indeed, Your Lordship, but the present case, the council stands firmly on the stand that the act of sexual intercourse has not happened in the first place. So when the act of sex, and that is something that is.
Then for what he has left the clothes and running away?
On this point, there is two versions. The prosecution is saying that after putting off his pants, the accused committed the rape. And the accused is saying that the victim started crying and he fled. Now, there is no iota of evidence to support the defense version, even its probability of defense version in this case. The young Bahadur, who was nearby present, has not stated that he heard the victim crying.
Indeed, Your Lordship.
And then the accused was seen fleeing from that spot. So the story that the victim started crying and then the accused fled away is not corroborated by the statement of young Bahadur. Then you have stated that no spermatozoa it was not found. But if we will go to para 11 of the Moot proposition, it is mentioned there that during course of rape, the victim started weeping, and then the accused fled away. There is no statement that there was ejaculation at all. If there was no ejaculation during course of rape, if the accused fled away in the mid of it, then there is no possibility of searching for spermatozoa on his cloth or on the body of the victim or anything. So there is nothing. If we compare both the statements, there is nothing on the record on the basis of which the statement of victim may be relied, particularly when the trial court and high court both have given a consistent finding on it. There is nothing. Even the defense story that no actual rape was not committed is not shown to be probable by any evidence or circumstance. No evidence or circumstance. So, if the accused was intending to falsely implicate the accused, then the accused must have been named in the FIR, but he has not been named, and this circumstance shows that the victim was not intending to falsely implicate him. She was not called to in order to falsely implicate him. Then, on what basis you are saying that the statement of victim should be discarded?
Indeed, Your Lordship. So, Your Lordship, I'll be answering the question in parts. First of all, when Your Ladyship asked the question about the age and the consent, first of all, my co-counsel has cited the cases that in the cases where I think she cited the case of Ms. Om Prakash, where she said in cases where the matriculation, it's not an uncommon knowledge that the matriculation certificate cannot be always relied upon, and the radiological age says that she was 18 above. Now we are standing on the ground that she was actually a major and not a minor. When we're standing on the ground, we are saying that the part of consent cannot be a question. Secondly, after that, we are saying that from our side, the act of sexual intercourse has not happened, and why the court should believe it should be under these grounds. First of all, the sole testimony that we are submitting to the court, that it has loopholes. Now, I'll explain why we think that it has loopholes and why these loopholes actually matter. Even regardless of the matter, like if we are able to convince the court if it's minor or major, we are able to tell you, we will be able to convince you that it's essential, because 3 months ago, and I'm not saying that a past lie should affect the present lie, but understanding the mechanism, how this is working and how it contradicts the statement, how it's essential. In the previous statement 3 months ago, she herself in the Moot proposition, it is cited that in the paragraph 11 only, she further stated, I was raped by Raghav 3 months ago also. I was very scared, thus I could not tell anybody. But I could not keep silence when the act was repeated. She says the act that happened 3 months ago has been repeated. Then she comes and tells us that the act what happened 3 months ago was actually teaching, which means the essential that is needed for the offense of rape, that is penetration, was not present in the act that happened 3 months ago. Now, when she says the same act has happened and now she's telling no, this is rape, then how is the court? How is anybody going to believe on that statement that the essential part of penetration has actually happened? Now, in light of this, when we discredit this fact that the penetration might not have happened, and there is something that still the accused is the prosecutor is not confirmed on and confused about, then we come to the medical corroboration. Your Lordship, thus medical corroboration is silent for them, and for us it is actually telling that nothing has actually happened. Your Lordship is saying that it might have happened in the middle of the act, and the presence of semen and is not present in the private part. Understood, Your Lordship. But there is the concept of pre-ejaculation, and also the fact that no external, not even a single scratch or the mark of a scratch. Your Lordship, even after 14 days, the lightest of the scratch has some kind of redness or purpleness or some kind of mark on your body, right? In the present case, the examination has shown no scratches at all, which shows that any part, major parts that actually substitutes us for us the offense of rape and the statement of the prosecutors cannot be in any way in reasonable doubt. In beyond reasonable doubt, can prove the guilty of the accused. And Your Lordship, in many cases, as I cited in my last issue of rape, it is stated that conviction can be based on full testimony of the prosecutors, provided it lends assurance of a testimony, and in case the court has reason not to accept the version of the prosecutors on its face value, it may look for corroboration. It was also held in the case of Narendra Kumar versus State NCT of Delhi. It is also stated in the case of Dilwar Saab Ali Saab Jakati, State of Karnataka versus State of Karnataka. The definition of rape as contained in section 375 IPC refers to sexual intercourse, and the explanation appended to the section provides that penetration is sufficient to constitute sexual intercourse and necessary to prove the offense of rape. In the instant case, the essential has not been established. Moreover, it admittedly proved that if there is forcible sexual intercourse, there will be injuries on the vagina, on the private party of the prosecutors. This was also held in the case of Yeru Mullah, apologies for my pronunciation, versus State of Andhra Pradesh. So, Your Lordship, to answer your question, why these according to you minor discrepancies and according to us major discrepancies should be given value in this case, is because these discrepancies actually show that the essential that is needed for rape, that is penetration, is actually in question, and there is a big reason for us to believe that this act has not happened. And whether the animosity, whether the relationship between the two existed or not, that is a minor question in the present case when we talk about the offense of rape. The major question is whether the act of rape has actually happened or not, and all the evidence, including the statement of the prosecutors, show that the act of rape has not happened, which gives the court reasonable doubt to believe that the accused should get the benefit of doubt and be acquitted of the charges. If Your Lordship is satisfied with the answer, may the counsel proceed?
Yes, proceed.
Yeah, you much obliged, Your Lordship. Your Lordship, I was talking about the fourth issue in the present case. When we talk about the medical evidences, also answering your ladyship's answer via this issue, it is very much clear, as I already said, that penetration is extremely needed, and from the fact of the present case, it appears that the element of penetration are absent. Now, when the medical evidence does not support the rape and there is no presence of semen.
No, you can't say the medical evidence is neither supporting nor repudiating. The medical evidence does not rule out the possibility of it.
Your Lordship, study done, and the law stated in Jai Singh P. Modi Medical Jurisprudence and Toxicology says that the presence of spermatozoa in the vagina after intercourse has been reported by Pollock 1943 from 30 minutes to 70 days, by Morrison 1972 up to 9 days.
I have already referred parallel that ejaculation is semen was discharged. It has not been stated by you. During the course of that, they accused straight away. This is the case of the prosecution. Hence, problems of spermatozoa is not likely there. So, spermatozoa was not found. On its basis, the case of the statement of prosecutors cannot be discarded.
Your Lordship,
The
the council
medical
is
evidence does not rule out the possibility of rape. It says that Hyman was there was whole tier of Hyman, or it neither rules out nor corroborates. So we have only oral evidence of prosecutors and the accused on the point what was happened at the time of murder. Now the statement of accused does not get corroboration from the circumstances, whereas the statement of victim gets corroboration. You are saying that the victim cried and then I fled away, but her cry was not heard by the witness, independent witness, Jang Bahadur. You are saying that witness, the victim herself called me and falsely implicated me in this case. But the circumstance that he was not specifically named in FIR rules out the circumstance that there was any intention to falsely implicate him. So that if the victim or her mother would have been intended to falsely implicate the accused in such a case, then it might have been specifically named in the FIR. Why there should be a doubt? If the victim would have called him, if the victim has seen him, then why there should be a doubt in FIR? Now, you have these circumstances, if we compare, so the defense version is not even remotely possible, whereas there is nothing on record on the basis of which the statement of victim may be discarded. When the medical evidence is not in contradiction with the case of prosecution, it does not rule out the chances of rape.
Your Lordship, the point is the submission that the council is making in the present case is that in the present criminal case, the burden of proof to all extent lies in the prosecution.
I'm quite aware of it. I'm saying that the burden on the accused is only to show probability of his defense. Now, your defense is not even probable. The circumstances are ruling it out. It is not even probable, your defense, that she called you and you fled away without having committed rape with her. Whereas the statement of victim is there and it gets corroboration from the circumstances. There is nothing.
Indeed, your Lordship. Indeed, your Lordship. Now, when
just a minute. Few minutes ago, my sister has asked you some question. That was with regard to section 114A of the Evidence Act. So that is exclusively for the rape cases.
Indeed, your Lordship.
Just now you have said that it is an obligation on the part of the prosecution to substantiate its case. So far rape case is concerned, when there happens to be denial at the part of the victim to have consented, then in that circumstance it is on the accused. The obligation goes upon the accused to substantiate that there was consent at the end of the victim, and you have to at least by way of cross-examination or something else probabilize this. So whether you succeeded.
Your Lordship, under section 114A of the Indian Evidence Act, the accused has to prove whether the consent was there or not. And if the woman says, if the prosecutor says that there was no consent, that is supposed to be taken by the court. That is something the council agrees with. But when the council talks about that the possibilities are to be and all the reasons and the burden of proof lies on the prosecution, the council is trying to say the possibility of rape and the act of rape, not the consent, whether consent is there, whether consent is not there. That we're not contending, because we are contending that sexual intercourse has not even happened. So the consent in this part, given or not given, does not play a major role. We are saying that the fact that rape has happened and there is no possibility at all in the present case to even believe that there's a possibility that rape has not happened. That's the proof on the prosecution to prove. And where my honorable lordship has said that the circumstances of the presented by the prosecutors are completely proved, the council would like to beg to differ in the present case, because she says she was dragged in the Sarpat. Again, I apologies for repeating the point, but I would like to reiterate these points because they're very essential in the present case, because she herself is confused whether penetration has happened or not, because she says the same act happened towards 3 months ago, and the 3 months ago what happened was actually teasing, and the elements of actually teasing, like not actually something physical happening. That is what the accused is also praying in the present case, that he was there, he took his clothes off, and she started weeping, and he ran away. Secondly, your honorable lordship also asked the question about Jang Bahadur. The Moot proposition is silent on the fact whether Jang Bahadur was an audible distance from the place of incident or not. So it is improbable for us to say whether he would have been able to hear her in the present case or not. The Moot proposition itself says, when it talks about Jang Bahadur, it says, when I was in my field at 8:30, who was easing himself in a nearby field stated, I saw in the light of torch that Raghav was running towards his home in a naked condition with only his underwear on. That's the only thing that the statement of Jang Bahadur says. We don't even know if he was in the hearing distance from that incident or not. So that cannot be a reason to corroborate the story of the prosecutors. Secondly, the injuries were not at all present externally or internally. Thirdly, the medical evidences and the private part that has been found, it is completely normal of a completely normal person and a woman who might have on whom the sexual activity might not have happened in the present case or in a recent scenario, right? And that is why the circumstances of rape cannot be 100% relied upon, and for that the accused should not be convicted, your lordship, because the act of the allegation of rape, I understand, and at the expense of sounding a little insensitive, and my apologies for that, the act of rape is extremely heinous, and we understand it's extremely wrong, and it actually destroys the dignity of a human being. But we cannot ignore the fact that a false allegations also completely humiliates and brings great distress on a man, and is equally humiliating and damaging for the person, and for the rest of his life it sticks with him, even if he's guilty of the offense or not. So in the present case, all the council is trying to submit is, your lordship, that there is a probable reason to believe that the act of rape, good chance, the medical evidence, the circumstances, her own statement shows that there is a good possibility that the act of rape has not happened in the first place. And by the act of rape, I mean the act of penetration in the sexual intercourse that has happened. When, your lordship, when you say that there might not have been ejaculation, there might, and the fact that the semen is not present, we completely accept, your lordship. There is a good chance that if allegedly, if it had happened and no ejaculation would have happened, we could not have found the semen. But there is no other injury on the body of the prosecutor itself. There's not even a single scratch. There's not even purple marks from grabbing her. From her statement, it says that during that act she started screaming and weeping, and she resisted in that case. And we cannot be believed to accept the fact that on the Sarpat, when a forcible act was happening on her, no injury happened to her externally or internally, which shows that the corroboration cannot be 100%. And in that present case, when we deal with the medical evidence, the prosecutor should get some benefit of the doubt and should be acquitted of the present crime.
Okay, for that time, taken by you is over.
Your Lordship, pardon, Your Lordship.
The time which has been allotted to you is over. Now let us
Indeed,
see
Your
the
Lordship.
opposite other party.
Your Lordship, with the permission of Your Lordships, may I proceed to the prayer?
Yes.
Much obliged, Your Lordship. Your Lordship, wherefore, in the lights of the facts, issues raised, arguments advanced, and authorities cited, it is most humbly and respectfully prayed that this honorable court may be pleased to adjudge and declare
appellant should be acquitted. The appellant is not guilty
of offense of criminal intimidation. The respondent, the witnesses are not credible, the existing evidence is not conclusive, and the appellant is not guilty of offense of faith. Much obliged, Your Lordship.
One thing.
Yes,
Now,
indeed, Your Lordship.
victim was minor.
Your Lordship, we stand the ground on the radiological evidence.
Victim was minor. Prima facie, there happens to be evidence that victim was minor. The occurrence is of the year 2019. The trial was not concluded and proceeded under POSCO Act. So, whether retrial could be ordered or not.
Your Lordship, we stand the ground that the age of the prosecutors is still a question of contention, and it cannot be 100% said that she was actually a minor on the day when the incident happened, because the matriculation certificate also says that she was 17 years 8 months old, and there is a chance of 4 months in the present case, which is ruled out by the radiological age. And when the offense of rape is also in the IPC and is also in the POXO Act, and the difference is that the only difference is that the punishment is stringent in the POXO Act. And
no,
I believe
two things are there. Kindly go through section 29 and 30 of the POSCO Act. That happens to be with regard to presumption and further with regard to mental condition of the accused. That the court has to infer.
Indeed, Your Lordship. But Your Lordship, to actually apply the POXO Act in the present case, we have to be extremely sure of whether she was minor or major at the time of the incident. And in the present case, it's a major point of contention because of the radiological age and because the matriculation certificate, because of so many judgments and legal precedents. It's already been stated that 100% cannot be relied on the matriculation certificate, hence making it a very big contention.
Section 94 of Juvenile Justice Act.
Your
Section
Lordship?
94 talks about the determination of age of a juvenile, which has been taken into consideration as per Rule 12 or in Jarnail Singh's case. As per Section 94 of the Juvenile Justice Act, the matriculation certificate is an authentic document for determining the age of even of a victim.
Indeed, Your Lordship.
Which has been considered in the matter of Jarnail Singh.
No, subsequently, there are three decisions are also of the Supreme Court.
So Section 94 talks about matriculation certificate, and you have not doubted about the authenticity of the matriculation certificate.
Your Lordship, I have in my written submission, I have, but due to the course of questioning and answering, and I could not present that issue. If you would allow, I'll present that issue right now only, if Your Lordship allows.
No, if you have the time. I haven't received the memorial. I have received the memorial just now only, so I haven't gone through that. So if at all there is there,
Your Lordship, it has been dealt with a lot of details and essential points.
But Section 94 talks about that. If matriculation certificate is there, then there is no need of any radiological examination with respect to the determination of the age.
Indeed, Your Lordship. The point, this sub-issue is, I think, sub-issue 4.3 in the written submission, that the documents presented by the prosecutors has infirmities, and it has dealt with the maximum amount of intricacies and details that it can be. Much obliged, Your Lordship. An honor to present before the bench.
Thanks.
Let the other side start. On behalf of the other side.
Sir, the speaker one of our team has some connectivity issue. She will be joining us within a second.
कनेक्ट नहीं हो रहा है, फिर दूसरे वाले लोग कनेक्ट नहीं हो रहे हैं, दूसरे वाले लोग कनेक्ट नहीं हो रहे हैं, दूसरे वाले लोग कनेक्ट नहीं हो रहे हैं, उनका केस हो गया। एप्लेट का रेस्पोंडेंट का होगा ना, स्टेट का,
Respondent है तो respondent team is there.
but they are not on.
They are not talking. Sir, can you just see? Respondents, are you there?
Yes,
Speaker.
sir. If you would just give us some time before the speaker one is having some technical issues on her part.
All right. Just do so quickly. Right. Sir is waiting.
Yes, sir. We apologize for the delay, sir.
All right. All right. Technical issue है.
अच्छा,
एक मिनट में आ जाएगा.
अच्छा.
थोड़ा सा.
आ गया हो?
Hello.
Yes, you're audible.
Okay, thank you.
Are the respondents here? Both the
Yeah.
respondents. Is your internet fine?
Yeah, so my internet is fine, but I actually cannot speak while holding my phone like this. So can I just switch off my camera if that's okay for the honorable court.
Sir, she wants to keep the phone down and switch off the camera. She's holding the phone. Lordship is allowing it. You can switch off your camera and keep the phone down.
Thank you so much, Your Lordship. Thank you.
Sir. Sound.
The council solicit the permission to begin.
Yes, first is whether you represent the state or represent the victim.
Sir, we represent the victim. We represent the state, sir. We represent the state because a crime is not just against a person. It is indeed against the entire society.
And you are representing the state.
Yes, sir.
Okay.
Shall I proceed?
Now, just a minute before proceeding ahead, your admitted case is that rape was committed.
Sorry, sir, I couldn't hear you.
Your admitted case is.
Yeah.
From the side of prosecution.
Yeah, rape was committed.
Yes, sir.
It is your case that both parties are on a strained relationship.
No, sir, they are not in a relationship.
A strained relationship.
Sir, I don't understand what you're saying.
A strained relationship.
Yeah. Yes, sir.
A strained relationship.
So, yeah.
Am I audible?
So actually not really clearly, but yeah, you can just proceed.
Yes. Now in the aforesaid background, and further, you were on litigating terms since before.
Sorry, sir.
You were on litigating terms since before.
Yeah. Yes, sir.
Was not possible at your end to disclose the name of accused at an earliest. When you disclose the name of disclose the incident to your mother, because he was known to you since before, he was your patidar.
Yes, sir.
Even being dark night, it is quite common to recognize a person being close from his voice, because he had uttered to face dire consequence in case you raise a voice.
Yes, sir.
Then why not you have disclosed the name of accused to your mother?
Sir, I like to state two things in this regard.
But just a minute.
Yeah, sure.
The second thing is whether the story of recovery of pant and gamcha at the instance of accused.
Yes, sir.
After 14 days of the occurrence is reliable one.
So can you just repeat this question?
I am coming to that. And the third, the relevancy of admission at the end of accused in accordance with section 313 of the CRPC, and what impact it has on the case of the prosecution as in similar way against the case of the accused.
All right, so shall I proceed to the answers?
That is.
Okay. So the first question you asked me, Your Lordships, was that why did she not disclose the name of the suspect to her mother? So in this regard, I'd like to state that rape is a heinous crime, and if someone has gone through such a process, such a heinous thing, if someone has gone through it, they are expected to be flustered at that moment. If someone is grabbing someone and they're just taking them forcefully somewhere, that takes a lot of mental peace at that very instant of the of the victim. So it's not really necessary that she might have realized that it is Raghav or not, but she suspected it. And that's why she stated that I suspect Raghav. Because
here is the point. Suspect why? There was confrontation, closeness. The case of rape was committed. Surely they both were in close contact. The accused was known since before. So he was her patidar. Litigation was going on. There was any sort of difficulty in properly identifying the culprit.
Your lordships, that is what I'm trying to say. If the prosecutrix was trying to concoct a falsehood, she would have definitely alleged blatantly that it is the accused who committed rape on me. But because she was not sure, because she could not see who it was, but she assumed, she thought of it that he might be the suspect, because due to the dark night she couldn't recognize who the person was. And it might be possible that we do not have the factual proposition of that time, but it might be possible that he changed his voice, or he did anything like that to hide his identity at that moment, which is why the prosecutrix was not sure of that whether it is Raghav or...
So there happens to be any sort of evidence on the record that yes, whether you have alleged in the FIR, whether in a statement under section 161, whether under section 164, you have alleged that victim had concealed his identity, and the rapist had concealed his identity, and so I failed to recognize at that very moment.
Your lordship,
how you came to know that the rapist was this appellate 4 days after the disclosure you have made to your mother?
Your lordships, that is what I'm trying to say, that the evidence of Mr. Jang Bahadur corroborated the said statement that Raghav ran away. Raghav was running from there in a naked condition, and furthermore, Raghav himself accepted to the fact that he was at the place of the incident. He accepted to that very fact, and since he accepted it, and since we have an eyewitness who saw him running from there, we can conclusively state that Raghav was present at the scene of crime. He was the suspect, and he was a suspect, and he actually committed the rape on her, which we shall substantiate by way of other arguments. If your lordship is satisfied with the above arguments, shall I proceed?
Yes, proceed.
All right, sir. So the second question, I actually told you right that time also. I am not really sure what did you ask in the second question. Can you please repeat yourself?
What impact a statement under section 313 CRPC is upon the case of the prosecution? Whether case of prosecution could be considered to be substantiated by the accused merely on the statement recorded under section 313 of the CRPC, or the obligation which the prosecution carries is to be properly discharged.
Your lordships, not just the mere statement of the accused under section 313 of the Code of Criminal Procedure, but also the statement of Mr. Jang Bahadur corroborated the entire incident. It's not just that the statement of accused that substantiates our arguments, but also the statement of prosecution witness substantiates our argument.
And the third aspect was whether it was a believable story that 14 days after the arrest, the pant and gamcha of the accused will be recovered from the place.
Sorry, sir. Can you repeat yourself?
14 days after the occurrence, there happens to be prosecution story that after apprehension of the accused, he disclosed that pant and gamcha, which he left on the date of incident, is lying there. He had gone there. and pointed out the gamcha and pant.
Yes, sir.
So whether this theme of recovery is really acceptable?
Yes, sir. Yes, Your Lordships, it is indeed acceptable because the accused himself accepted that he left the pant and the towel at the place of the incident himself, and upon him alleging that he actually left those clothes there, the police went to the scene of crime and they found out those very clothes lying there itself. It is not a material evidence, sir, that the clothes might not have been worn out of time or something, but the point being that the accused himself alleged that at the time of the crime he actually left his clothes there and then he ran away.
So in the forced background, one could consider the objective finding of the IO with regard to place of occurrence, whether the surfeit was found from Retd or anything objective finding with regard to place of occurrence, suggesting mishappening of any kind of mishappening.
I would like to point out at this stage in para 11, it has been mentioned that during the course of occurrence, the cloth of the victim was torn. Why the torn cloth was not produced before the police and it was not exhibited in the case? It was not.
Sir, Your Lordship, please.
In the para 11, there is mention that during course of occurrence, the cloth of victim was torn. Where are those torn cloths? Why it was not produced before police at the time of lodging FIR at the time during investigation? This was mark of violence, mark of use of force is there. It may be evidenced by producing the torn cloth. Even if there was no injury found on the body of victim, it is a specific case, a specific statement of the victim that her cloth was the accused committed the act of rape by tearing her cloth. Where are those torn cloths? Why it was not been exhibited or brought in evidence by the prosecutor?
Your Lordships, the questions you have raised to me in the instant case are all related to the basic evidences and the investigation, which shall be dealt by my co-counsel. I'm here, as in my power of counsel number 1, is here to discuss the jurisdiction of this case and the testimony of the witness.
The jurisdiction, you mean to say you are here to state about the maintainability of this appeal, especially?
Yes, sir. Yes, Your Lordships. I am here. The basic arguments that I am dealing with.
Whether the High Court has reappraised the evidence of the witness in its judgment, or it only endorsed the findings given by the trial court. Whether it is necessary for the High Court as a matter of as a court of first appeal, whether the High Court was obliged to reappraise the evidences.
Your Lordships, the High Court would be obliged to reappreciate the evidences, and it actually did that. It actually reappreciated all the evidence, and it reappreciated the principle that was applied by the trial court, and only then and only on these legal findings and the legal principle applied by the Honorable Trial Court, the learned High Court based its judgment and concurred with the judgment of the learned Trial Court. And if you
what the Moot proposition states, the High Court rejected the appeal by observing that the finding of trial court is based on fair appreciation of evidence. It has only gone through the judgment delivered by the trial court and came to conclusion that there is fair appreciation of evidence by the trial court. It has not itself appreciated the evidence. I am just asking. The appreciation of trial court is fair one. It is one thing, the appreciation of the evidences by the High Court itself. Independent appreciation of evidence is relative. Whether
Your,
it
Lo-
can be said to be a concurrent finding of fact.
Your Lordships, if I may give my answer to the question.
Yes, yes.
Your Lordships, the judgment of the Honorable High Court says that they do not find any illegality or perversity in judgment of the learned trial court. This means that they have actually perused all the findings of the trial court. They have gone through what the trial court's rationale was, on what basis has the trial court convicted the accused, and are the evidences fairly interpreted, is the legal principle properly applied, and that is why they base their decision that it is a settled law that if the finding of trial court is based upon legal evidences and their fair interpretation, then such finding should not be disturbed.
Okay.
Your Lordships, if I may proceed with my arguments.
Yes, yes. Proceed.
Since time is limited, so I'll be presenting my arguments in a very limited time frame. The first claim to the argument is that because of the power plenary of this honorable court under Article 136 of the Constitution of India, the court has set self-imposed limits, that is not to permit invocation of this power except under the exceptional circumstances, such as when a substantial question of law or general importance arises or a decision shocks the conscience of the court. However, this apex court, in the case of Santosh Hazari versus Purushottam Tiwari, 2001 SEC 3179, has held that if the question is settled by the highest court or the general principles to be applied in determining the questions are well settled, and there is a mere question of applying those principles, the question would not be a substantial question of law or general importance. Thus, the counsel for the respondent humbly submit that since in the instant case, the trial court as well as the High Court have based their findings on legal evidences, their fair interpretation, and settled principles of law, the petition should not be maintainable. Furthermore, your Lordships, the counsels for the respondent humbly submit that the counsel for petitioners must show the exceptional and special circumstances that exist. And if there is no interference, it will result in substantial and grave injustice. The case must also have features of sufficient gravity to warrant the review of the decision appealed against on merits. Furthermore, your Lordships, normally in exercising its jurisdiction under Article 136, the Honorable Court does not interfere with the findings of the fact concurrently arrived at by the courts unless there is a clear and blatant error of law or unless some important piece of evidence has been omitted from consideration. Since order of the High Court and observations of the trial court have been based on these legal evidences, the SLP is not maintainable. Your Lordships, the counsels for the respondent humbly submit that as has been held by the Honorable Trial Court and High Court. We furthermore state that law is settled on the point that in a case of rape, if the evidence of the victim of offense of rape is found to be wholly reliable, then the same can be made foundation for recording the conviction against the accused. The counsels for the respondent humbly submit that as has been repeatedly held by this court in a catena of cases, the sole testimony of the witness is sufficient to establish the commission of rape, even in the absence of corroborative evidence. Reliance has been placed in this regard, your Lordships, on the decision of this court in the case of Muhammad Iqbal versus State of Jharkhand, where it was held that there is no prohibition in law to convict the accused of rape on the basis of sole testimony of the prosecutrix, and the law does not require that his statement be corroborated by the statements of other witnesses or in material particulars. Furthermore, your Lordships, as has been held in the Rafiq case, in the case of Rafiq versus State of UP, when no woman of honor will accuse another of rape, since she sacrifices thereby what is dearest to her, her dignity, we cannot cling to a fossil formula and insist on corroborative evidence, even if taken as a whole. The case spoken by the victim strikes a judicial mind as probable. When a woman is ravished, what is inflicted is not merely physical injury, but It is not merely physical injury, but the deep sense of some deathless shame. Judicial response to human rights cannot be blunted by legal bigotry. Your Lordships, in a similar spirit, the Supreme Court, in Sheikh Zahir versus State of Bihar, has held that the absence of any injuries on the person of the complainant may not by itself discredit the statement of the complainant, merely because the complainant was a helpless victim who was by force prevented from offering serious physical resistance. She cannot be disbelieved. The inherent bashfulness of the females and the tendency to conceal outrage of sexual aggression are factors which this court should not overlook. Seeking corroboration of her statement before relying upon the same, your Lordships, as a rule in such cases, amounts to adding insult to the injury. The counsel for the respondent further submit that as has been held by this honorable court in the case of Pattu Rajan versus State of Tamil Nadu, there must be a chain of evidence proving the circumstances so complete so as to not leave any reasonable ground for a conclusion of innocence of the accused. Your Lordships, as has been aptly put in this quoted phrase, men may lie, but circumstances do not. Human agency may be faulty in expressing the picturization of actual incident, but circumstances cannot fail or be ignored. We believe, your Lordships, that in the instant case, the most plausible explanation shall be that Raghav and his father wanted the prosecutrix's family to withdraw from the pending civil suit, that Raghav secretly loved the victim, and upon her refusal, his agony shot up to such a height that he raped her, killing two birds with one stone for taking revenge from the victim and to threaten the family to back out from the dispute. It was the victim here, your Lordships, who gathered strength and reported the incident, with hope that justice shall prevail. On this note, if your Lordships have any questions, I can answer them. Your Lordships, am I audible?
Yes. Anything more to ask by you?
Sorry, sir?
Do you want to ask anything more? Any point
No,
more?
sir. My co-counsel will be now taking the charge from me.
Now, yes, co-counsel should do. So present her case.
If it pleases this honorable court, this is counsel number 2 appearing on behalf of the petitioner. If I may begin with your Lordship's due permission.
Yes, yes.
The counsel would be dealing with issue number 3, that is, the accused is guilty under section 376 of the Indian Penal Code. The reasoning has been divided into 4 parts. The counsel for the respondent humbly submits that under section 375 of the Indian Penal Code, rape is defined as a man is said to commit rape who has sexual intercourse with a woman with or without her consent when she is under the age of 18, which clearly shows that the consent of the prosecutrix is immaterial in this case because she was a minor. Under section 114A of the Evidence Act, the court presumes that the woman...
I'm sorry. If the prosecution case is that the prosecutrix is minor, then why no offenses under the POCSO Act has been registered against the victim, the accused? You have only alleged 376. If you were having the documents which proves that the prosecutrix was minor at the time of commission of the offense, then there is a special legislation for protecting the dignity of the child. So why have you not registered the case under POCSO Act when you were having a benefit under section 29 of the Act with regard to the presumption against the accused? Then why have you not registered it?
Indeed, your Lordship, the council decided to follow up the case under the Indian Penal Code, that was specifically under section 376, with regard to the fact that it offers a harder and more rigorous punishment to the accused.
I think POCSO has more harder punishment than 376. If you would be having a look at the recent amendments in the POCSO Act, then you would be very well aware of this fact that the sentences that has been provided in the recent amendment is much grievous and harder as compared to section 376 or the punishment provided in the penal provisions.
Indeed, your
I have only a question with regard to the age. If the prosecution was sure about the age of the prosecutrix to be minor, then they would have certainly registered the crime under the POCSO Act.
Indeed, your ladyship, we are certain about the age of the prosecutrix. So has been proved by the matriculation certificate, as you yourself on previous occasions stated the case of Jayanti Lal and that to the Juvenile Justice Act as well. Then we refer to the matriculation certificate as a definite proof for determining the age of the prosecutrix in this case, which was close to 18, but she was not still 18, but still the council decided to pursue the case under the Indian Penal Code. If I may continue, your ladyship.
You can. You may.
Thank you. The council would like to state that if a female minor enters into a sexual relationship, then the question of age vanishes from the scene because the consent is immaterial. It is also to be noted, your lordships, that the so-called consent that my opposing counsel is mentioning was obtained by threatening the prosecutrix and that she would have been killed if she did not have sexual intercourse with the petitioner. In her statement, the prosecutrix has mentioned a threat by the petitioner. She explicitly stated that when I tried to shout, he threatened that he would kill me. A threat of dire consequence has also been supported by prosecution witness number 6, Gauri, who happens to be a classmate of the victim in her statement, which said that he threatened the victim that if she did not marry him, she would have to face the consequences and left the place. The opposing counsel mentioned that there was a romantic relationship between the accused and the prosecutrix, but this was not the case. The entire relationship was only one-sided. That is Raghav. It was Raghav who teased as well as followed the prosecutrix without her consent. This points only to the fact that the petitioner had malicious intentions from the very beginning and is of questionable moral character. This act of rape was nothing but an attempt to get back to the prosecutrix for the rejection of his proposal of eloping with him, as well as the family enmity which always and already persists between both the parties. Thus, in light of the aforesaid argument, the counsel for the respondent humbly submits that the consent of the prosecutrix, even if given under threat, is immaterial in the present case. Now, moving on, rape is the most morally and physically reprehensible crime in the society. Through her statement, the witness has expressly stated that she had been raped. It has been further submitted that conviction for rape could be found on the testimony of the prosecutrix alone unless there are compelling reasons for seeking corroboration. However, the evidence of prosecutrix is more reliable. Even minor contradictions or insignificant discrepancies in the statement of prosecutrix should not become a ground for throwing out an otherwise reliable prosecution case. Even in cases where injuries are absent, rape charges cannot be considered fabricated because the rape trial is such a harrowing experience that no woman would admit it on her own. The absence of any injuries on the person of the complainant may not by itself discredit the statement of the complainant. Merely because the complainant was a helpless victim who was by force prevented from offering serious physical resistance, she cannot be disbelieved. Once it is found that the version of the prosecutrix is worth relying, then it goes without saying that the offense of rape is duly proved. The court has always held so far as the prosecutrix is concerned, mere statement of the prosecutrix herself is enough to record a conviction when her evidence is read in its totality and found to be with reliance. To insist on corroboration, except in the rarest of rare cases, is to equate one who is the victim of the lust of another with an accomplice to a crime and thereby insulting womanhood and nothing else. Thus, the counsel for the respondent humbly submits that the above evidence as well as the statement of the prosecution witnesses can be construed as enough evidence that rape has been committed. The counsel for the respondent humbly submit that a mere delay in lodging the FIR cannot become a ground by itself for throwing the entire prosecution case out. In the Indian society, victims of crimes such as rape ordinarily consult relatives and are hesitant to approach the police, since it involves the question of morality as well as chastity of the woman involved. A woman and her relatives have to struggle with several situations before deciding in filing the FIR, sir. Relying on the above statement, the court has also held that in such cases, the delay is understandable and merely on that account, the prosecution version cannot be doubted. The counsel for the respondent further contend that the court...
There is delay at two stages. Firstly, the victim causes delay of 10 days. in
Yes, sir.
saying about the incident to her mother. Then her mother also causes a delay of 4 days in lodging
Yes,
the
sir.
FIR.
Yes,
You are
sir.
talking about the victim. The victim may be hesitant, she was threatened, she might not have hesitant in telling the
Yes, sir.
incident to her mother. But what is the explanation of delay in lodging FIR by the mother of the victim? Why she was not explicitly threatened by the accused? Why she committed a delay of 4 days in lodging the FIR?
Indeed, Your Lordship, I absolutely agree with your point that there was delay on two stages. So for the first part, the delay would owe to the fact that the girl, first of all, was a minor, and rape is a heinous and drastic crime happening to a woman. She was also not sure what was happening around her, and it took her some time to open up to her mother. And to the explaining the second stage of delay, that is the 4-day delay from 24th of August to 28th of August, the council would state that, as stated before, rape is a very serious crime and it would seriously affect the chances of the woman getting married in future. We also cannot deny the fact that the accused were the patidars of the victim in this case and hold a position of dominance over the victim. So
There is explanation of the delay of first 10 days that the accused has threatened. It is in evidence. But what causes, what restrained her mother to lodge the FIR, whether she was taking opinion of some relatives or anybody, or whether she was also threatened, why she made a delay of 4 days, there is the entire evidence is silent on this point. Now you are, as a lawyer, aiding the explanation on your own, but the evidence is silent. There is no explanation at all as to why the mother of the victim did not lodge the FIR after having knowledge that the accused has committed rape with her daughter. There is no evidence, there is no explanation at all by the prosecution side in evidence. It is only an speculation by the lawyer. आप जो है gesture पर you are working on a gesture. It may be, it may not be. This is the society, custom bound society, and this and that. But what really restrained her from judging FIR, she has not stated a single word about that I was taking advice from some, I was apprehensive from the accused person. There is no explanation at all of these 4 days delay.
Sir, if we look at, I would request you to refer to the Moot proposition, that is para number 12. Sarita Devi in her statement stated, I would request you to refer to second last line, in which Sarita Devi said, she also told me that the person threatened her that if she will disclose the incident with anyone, she would be killed. It clearly shows that the victim was threatened and the mother naturally was concerned about the life of her daughter, and the delay in fact is not a very long delay. 4 days, sir, is not a very long period of time, especially concerning the fact that this case is that of rape, which is indeed in itself is a very heinous and serious crime in the society. We can also not overlook the factor that that her father was dead, her mother was the only sole earner of the family.
The lines of para 12, which you have quoted, is the explanation of delay of first 10 days. The victim told that the accused had threatened her, and hence she was not, she did not disclose the stated about the occurrence to her. This is the explanation of first 10 days. Now, then, when there is no explanation at all of the next 4 days, why the mother of the victim did not lodge the FIR.
So the statement of Sarita Devi itself, that she told me that the person threatened to kill her daughter, was enough to cause a delay of 4 days. And we have to refer to the fact that 4 days is not a very long period of time for delay in filing of FIR. And that too after the fact that the victim herself was threatened.
The statement of Sarita Devi is that she also told me, here she stands for Sarita Devi, for the victim,
for the prosecutrix,
and me means Sarita Devi. She also told me that the person threatened her that if she will disclose this incident with anyone, she would be killed. There was threatening to the prosecutrix. There was not threatening to Sarita Devi.
Sir, but Sarita Devi, being the mother of the prosecutrix, was naturally concerned about the life and circumstances of her own daughter. And we cannot by any chance overlook the factor that there was already a family enmity between both of them, and the family of the accused holds a position of dominance over that of the prosecutrix, which in cases of rape plays a very major role. So if I may continue with the arguments.
Yes, continue.
Thank you, sir. The counsel for the respondent further contends that the court cannot overlook the fact that in sexual offences, delay in lodging of FIR can be due to a variety of reasons, particularly the reluctance of the prosecutrix or her family to go to the police and complain about the said offence. The Honourable Supreme Court in the case of Ravinder Kumar and another versus State of Punjab has observed that the attack on the prosecution cases on ground of delay in lodging FIR has almost bogged down as a stereotyped redundancy in criminal cases. It is a recurring feature in most of the criminal cases that there would be some delay in furnishing the first information to the police. It has to be remembered that a delay in FIR is not illegal. The counsel for the respondent further submit that the Honourable High Court in a catena of judgments has acknowledged that the victim of an FIR, filing of the FIR merely on the ground of delay in lodgement cannot be approved as a legal corollary. Even if there was a delay in lodging FIR, the court is to look at the cause for it, and if such causes are not attributable to any effort to concoct a version of consequence, shall be attached to merely delay in lodging FIR. In case of Lokesh versus State of NCT of Delhi, it has been held.
You have already referred several reasons. Proceed to other point.
Yes, sir.
I would just be asking one question to you. Whether
Yes,
do you think, taking into consideration the evidence and the statement of the prosecutrix, the evidence of the prosecutrix is of such sterling quality and she's so creditworthy that the whole conviction can be based on the basis of her evidence, sole evidence of the prosecutrix, considering the fact your own case is that the prosecutrix was known to Raghav, as she has in para number 9 under the statement of the parties, they have clearly stated that there was enmity between them. She has asked to marry him. There was an incident of teasing with that. And so she might be very well aware of the, at least not in the dark, if she, though she hasn't stated in her evidence that there was dark, so she could not recognize the accused. But she has stated that the person has threatened her with dire consequences. So even if a person could not be recognized by the face, then also his voice was very much recognizable. So if she could have recognized the voice and a dire consequences threat has been given to them, to the prosecutors at the time of the incident, then how she could not recognize that person at that very time, and all of a sudden on 24/8/2019, when she disclosed this to her woman, she got enlightened and gave a suspicion with regard to the identity that the person could be Raghav. So in fact, if at all, what my say is that taking into consideration the evidence and the change of the stances of the prosecutrix, can the evidence of the prosecutor, on the basis of sole evidence of the prosecutrix, we can base the conviction of the accused on her evidence, and her and the witness is of such a sterling quality and of such a creditworthiness that her evidence should be accepted as a gospel truth?
Absolutely, Your Ladyship. When I refer the counsel still stands with the contention that when the statement of the prosecutrix is read in light with the facts of the case as well as the evidence is procured, we can conclusively reach to the conclusion that this was indeed a case of rape, and Raghav was a Raghav had reasons to be a prime suspect, and even the person there was Raghav. I would first refer to the statement of the prosecutrix. She suspected that Raghav was there on the basis of the voice, or on the voice only.
Hasn't been there. She could not recognize that person. It was very dark and she could not recognize. On the next line, she says that when she tries to raise the alarm, the person threatened her with dire consequences. This was her statement, and at the time of FIR, this was the contention.
Indeed, Your Ladyship. So if I read the para 11 which you're referring to, she said that as it was very dark, so I could not see who the person was. And as you're referring to the
Not
person
recognize, but at least she could recognize the voice and
that
give.
is, yes, ma'am. That is the sole reason that she said in front of her mother as well as in front of the investigating officer that she suspected that it was Raghav in the first instant. Second, we cannot ignore the statement of the prosecution witness number 4, Mr. Jang Bahadur, who through his flashlight saw Raghav running in a naked condition through the field. Third, ma'am, we cannot ignore the history of the case and history between both the parties. Raghav on several occasions before had tried to tease the prosecutrix. He had the intention to do something bad to her when he threatened her that if you do not elope with me, I will do something threatening to you, something that you will regret. In such a situation, everything points to the very fact that Raghav had this malicious intention within him. And also, we cannot by any chance ignore the statement of the accused himself, who has agreed to the fact that he was present at the place of crime. If I may continue with the argument, Your Ladyship. Thank you. The counsel submits that, as has been said earlier, the victim was examined after about 14 days of the alleged incident, which would mean that any spermatozoa would have died in that time period. So the chances of any positive findings giving rise to inference of sexual assault must have vanished during such a long interval. A similar view was in the case of state of Maharashtra versus Chandra Prakash Kevalchand Jain. It was held and asserted that spermatozoa can be found only if a woman is examined within 12 hours after the intercourse. Thereafter may be found between 18 to 72 hours, but in dead form. In this case, the court, after satisfying itself regarding the presence of semen on the clothes of the prosecutrix, held that the absence of semen or spermatozoa in the vaginal semen and slides cannot cast doubt on the circumstances of the prosecutrix. It is a piece of circumstantial evidence, but by no means conclusive. Examination of smegma loses all importance after 24 hours of sexual intercourse. Thus, in view of the aforesaid argument, the counsels for the respondent humbly submit that the absence of spermatozoa and vaginal smear does not falsify the version of the prosecutrix, and it certainly cannot be a ground to doubt the prosecution's case. Your Lordships, my client was just a minor The prosecutrix was just a minor who on earlier occasion had been threatened by the petitioner with dire consequences, that if she did not agree to the plans of Raghav with running away with him, she would have to face something very bad. The petitioner is a habitual molester who had on several earlier occasions tried to tease, threaten the prosecutrix, painting a very loathing picture of his character. Being the most hated crime, rape tantamounts to a serious blow to the supreme honor of a woman. Rape is not only an offense against the person of a woman, rather a crime against the entire society. And it violates the most cherished rights a woman holds. Therefore, in this case, the accused should be convicted under Section 376 of the Indian Penal Code. If you would allow, Your Lordships, may I move to the prayer?
One thing I want to ask. In this case, the accused is not completely denying his positions on this part. His plea only this, that it was not a completed act of sexual intercourse. He was present there. He had gone there with the intention. But since the victim started crime, he fled away from there. He didn't committed sexual intercourse with the victim. Now, since the FIR was lodged after much delay, we don't insist about the presence of injury or responsibility. We don't expect these evidences, but the evidence shows that the accused committed a rape after touring the cloth of the victim. Now, this is an objective evidence which has not been brought by the prosecution in this case. Where are those torn cloth? Why it was not produced by the victim or the mother before the police, or why it has not been collected by the IU in course of investigation? If it is alleged that the cloth of the victim was torn and it has not been produced, it has not been brought in evidence, what presumption or what will be its consequence?
Sir, not presenting the clothes should not conclude to a major...
Torn clothes. Yes, she has stated that the cloth was torn, para 14. She has said that the accused committed rape with her after touring her cloth. That was torn, touring her cloth. The accused committed Now the whole clothes are to have been produced in the case, but there is no mention that any cloth cloth was produced as evidence in this case. Also, there is evidence that cloth of accused was produced, but clothing cloth who have not produced. What will be the explanation of prosecution about this omission?
Your Lordship, the clothes of the prosecutrix indeed were not presented, but this in itself cannot become the ground for proving that her statement in itself was false. So the act never really happened, because we should also consider the fact that Raghav had taken his clothes off. He on prior occasions had threatened the prosecutrix, as well as he had the intention of getting married to her, which amounts to the fact that he wanted to have sexual relationships with her from the very beginning. So this all proves to the fact that Raghav had malicious intentions, and not the clothes of the prosecutrix not being present don't play.
The intention is not denied. He has admitted in 313 that he went to that place, he was present there, he put off his pants, showing his intention that he wanted to cohabit with his lover. He has admitted it. The only thing which has been denied by the accused, that he did not actually commit the offense. Straight away, because the girl started crying. Now, as against it, the case of prosecution, the case statement of the victim is that the accused committed rape with her after closing her. Now, this, if the torn cloth would have been produced by during trial, it would have belied the defense story also, and it would have given substantial corroboration to the statement of the prosecution. Thus, and a very important piece of evidence which could have been produced has not been produced, and what presumption, what should be its consequence? What is the
Indeed,
explanation
Your
of
Lordship,
prosecution for not producing those two during trial? What is the
indeed,
explanation?
Indeed, Your Lordship. Sir, the consequence of such a mistake, the council would state, should not amount to throwing away or doubting the case of the prosecution, as is in this case. As far as the clothes of the prosecutrix are concerned, they could have been substantial evidence in the case, but could not be produced in the present case. But this in no way, sir, means that the act of rape actually did not happen. All the circumstances and facts of the case point to the thing that that rape actually happened, and the lower court, as the lower courts have indeed upheld this the judgment that the act happened, despite the fact that the clothes of the prosecutrix were not produced. Other evidence were deemed creditworthy enough by the lower courts to uphold the judgment that the accused is indeed guilty of committing rape on the prosecutrix.
Okay. If there is any other point, we are good by you.
No, Your Lordship, if you may allow, I would like to move to the prayer.
Yes.
Thank you, Your Lordship. In the light of the issues raised, arguments advanced, and the authorities cited, the counsel for the respondent respectfully requests the Honorable Court be pleased to adjudge, hold, and declare that the special leave appeal should not be granted to the petitioner, that the evidence of the prosecutrix is wholly reliable, and that the conviction of the petitioner under Section 376 of the Indian Penal Code be upheld, and issue any other order as this Honorable Court may deem fit, just, and proper in the facts and circumstances of the case, in the light of justice, equity, and good conscience. And for this act of kindness, the counsel for the respondent shall be duty bound forever. Thank you very much, Your Lordships. It was an honor pleading before the court.
Anything from the side of appellants in this?
Indeed, Your Lordship. Your Lordship, if you would grant me 2 minutes for rejoinder. You much obliged, Your Lordship. Your Lordship, the major contention between the parties have been two charges: criminal intimidation and the charge of rape. In the present case, the respondent has failed to even deal with the charge of criminal intimidation in the written submission only. And secondly, when we talk about rape, there is my respected opposition counsel have dealt with the idea of rape with the fact that everything around rape does not lead to acquitting the appellant. whereas the actual offense of rape has not been dealt with the respondent, and they have in no way showed us how the act of sexual intercourse, i.e., the essential for the rape, that is penetration, has happened and how it has happened, and the possibility that it might not have happened is not in the picture, and that is not what has been brought to the attention of the court by the respondent, Your Lordship. Your Lordship, we also would like to submit that the respondents, when they talk about medical evidence, they say that after certain amount of time it cannot be dealt with. Whereas they completely they do deal with the fact that after so many days, but they completely uh, uh, ignore the fact that it was actually the prosecutrix her own fault that she came after 14 days and the examination was done after the 14 days, and it is not the fault on the part of the accused that the medical evidence does not show anything, and the onus of that goes for the fault actually goes on the prosecutrix, which leads us to believe that there might have been some kind of concoction on the part of the prosecutrix herself. Where the second thing, that Your Lordship, which your ladyship very well brought to the attention of the court, that she did not even recognize him by the voice, by the touch, by the image of his body. She did not recognize him at all. And in his statement, she completely accepts the fact that she does not at all recognize who the person was, but she suspects out of nowhere, out of thin air, she suspects that it was Raghav. And then comes out to say that it was Raghav who did this heinous crime. At the expense of sounding a little insensitive, Your Lordship, I accept the fact that rape is a tantamount it's a very heinous crime and it should be taken seriously, Your Lordship. But the
There
only
is
permission,
obstruction in the admissibility.
pardon, Your Lordship.
You are not audible.
You're audible now, Your Lordship. Is his Lordship audible? If I have the permission of Your Lordship, may I proceed?
I think there is muted.
Yes, it shows that he's muted. Your ladyship, your lordships are not audible or visible. Please direct what I should do next.
I think he has lost. Honorable Justice Trivedi ji, can you please unmute your mic?
There is some
technical problem is there. I think there is some technical problem. He is not able to connect with the.
So, your ladyship, should I proceed or?
I think you have to wait because both of the other judges are not there. So I think.
Indeed, your ladyship. Indeed, your lordship.
I would be asking the moderator or the court master to just give the judges the call so that if at all they are.
Yes, ma'am, they have already joined. They're connecting to their audios. So I guess 2-3 minutes more.
Okay. I think there are certain technical issues with them, so you have to have patience and just please wait.
Very sure.
Yes, ma'am. Just they are joining, but they are unable to connect to the audio. So just we can wait for 5 minutes.
Hello.
Yes.
All right. आ गया बस सर
आपको अगर खत्म करना हो गया और क्या करें
hello.
Yes.
Sir is asking if the round is over.
The only I was submitting my last submission for the rejoinder, and that would have been it.
I think you can complete.
My lord, they are waiting for your permission to continue.
Hello.
Yes, my lord.
There is some issue with the internet. The round just disconnected on sir's laptop.
You are audible.
We are audible, no? Sir is asking to summarize it just quickly.
Yeah, my last submission, the council's last submission from the appellant side is that the burden of proof on the side of the prosecution, side of the respondent, was to rule out all the possibilities of the commission of rape. In the present case, they have not even dealt with the essential condition of in sexual intercourse, i.e., penetration, to a limit where it can be said that beyond reasonable doubt, the guilt of the accused is justified by the conviction of the High Court and the trial court. Much obliged, Your Lordship. A pleasure to contend before the court.
Should we move to the sir rebuttals, ma'am?
I think so. I'm not sure that whether I can on my own give you the permission, because we already have 2 more judges. So I think I should wait.
Indeed.
Just 2 minutes, ma'am. They are connecting.
All right, it's all right. I don't have any issue. It's already Sunday, so I have kept the whole time for you all people.
That's great. Thank you, ma'am.
And I think it's a pleasure hearing all the parties. You all have done a commendable job, and especially if the females are doing so much in the legal field, I feel exhilarated.
Much obliged, Your Ladyship. Thank you so much.
Teams, are the judges present?
I'm present. I don't know about the others.
Very good evening, ma'am. I think sir's internet just disconnected. Sir will be marking everyone. I think the round was over by the time is
I think so, because all of them have already completed their submissions. So whatever marking we have to give, it would be based on the submissions they have earlier given prior to their being disconnected. So I think the round, whatever you decide, I don't know.
All right, ma'am. Heartiest congratulations to the participant. They have shown their vigor, vitality, and they have presented their case, their plea, their submissions in proper way. They have shown proper ethics while presenting their plea. Thank you. Thank you.
Much obliged, Your Lordship.
Thank you
Thank
so
you,
much.
my lord.
One, I think, applaud you all for one thing, that whenever the judges were raising the queries, you all are coming out of your comfort zone and then giving the answers. It was commendable and very, I think I was appreciating all of you. I don't have words to describe that. And I wish you all the best in your career, in your academics, everything. Wish you all the very best.
Thank you very much, ma'am. It means a lot.
Your Lordships, if I may comment something here.
I don't know. You can. You can.
Ma'am, before parting, I just want to say that whatever the result of this competition may be, it has been an honor to plead before you all, and it has been an honor to plead against such a potential council.
Indeed.
It has been an honor for us, and
I think
it really
Absolutely. Without any doubt. And the happiest situation, as ma'am mentioned before, was that I came here and I saw there were two girls. The researcher, it's an all-women team. And I was so happy for the first time I was competing against an all-women. It is really nice to see women competing with women, being a part of the case which involves
Healthy
women.
competition between all of us.
Let this
Let's take on
equally
the behalf of my-
rating in the whole of your life, that you would be excelling and succeeding in everything which you do.
Much obliged.
Thank you very
I
much.
can
so
say
much,
that
ma'am.
as far as on my part is concerned, that this profession is very much, I think it would be certainly very much beneficial to the ladies, as because we are more convincing. The convincing power is being given by the God to us, and we would be, if at all we would be, if you all would be going into the litigation field, all of you would be doing very well, and I give you all a lot of my best wishes for the life to come for you.
Thank you very much, ma'am. Thank you to the rest of the judges as well, and thank you to the organizing committee as well. You people were commendable and amazing. Organizing such a big event in 3 days, you completed everything. It was amazing. It was amazing. Thank you very much for the experience.
Thank you, ma'am. Thank you, everybody. Thank
To
you.
everybody, ma'am. I cannot say, ma'am, like it's been like 2 months, ma'am, and the last 3-4 days have been a sleepless night for us. And like, ma'am, you are mute.
Yeah, I think a huge round of applause to you all, to every one of you who have done well, participated.
Absolutely.
Everyone, thank you so much. It was a pleasure and honor to be a judge amongst you all. So thank you so much.
By God grace, by Allah grace, ma'am, there have been 93 members teams who have participated. We had never ever expected 93 teams to come for a first time Moot.
Thank you.
And
Wish you
it
all
has
the
been-
very best. Wish you all the very best. Thank you so much. Thank you. I would be taking leave of every.
Ma'am, you're muted.
Ma'am, you're muted.
Thank you, everyone. I would be taking your leave, and have a very nice Sunday.
Ma'am, the mask.
Thank you, ma'am.
Thank you, sir.
One thing I would like to say, each of the participant has presented the respective case very clearly, very boldly, very honestly, very effectively. But one thing was lacking. I only suggest after closure of this competition, there was no argument on the point of sentence at all. The appellants might have made an alternative argument on the point of sentence, but it has not been done. Even in the reply also, no alternative argument on the point of sentence has been made. Otherwise, on all other points, on all other questions which were asked by the judges have been heavily answered by all departments.
Thank you very much, sir. Thank you,
Much
everyone.
obliged, Your Lordship.
Thank you, sir.
Layers and the सारे participants के लिए जो है good future के video. Thank you. Good
Thank you,
message
sir.
to
Thank you
all
for
of
giving your precious time to us, sir.
Thank you, sir.
Thank you so much, sir. Thank you so much.
Should the participants leave now?
My lord is still there in the room, so that is
Oh,
why
yeah, I'm sorry.
able to say anything on this part. Till the time.
Just wait a minute. Ma'am is there? Fouzia ma'am?
Sam has left.
All right. To all the to both the teams, I'm letting you know that you all argued till two judges exhausted their internet.
I don't know whether the teams know or not, but they are getting a very good cheer on the YouTube as well.
That is amazing, and that is good for your for Dreamlaw as well. I think it's on your channel only. I checked the YouTube channel.
Performance. I think Dreamlaw has been getting a lot of praises for providing.
Yeah, exactly.
Congratulations on that.
All right, and thank you all for the patience. I know you all did not get much time to read each other's memo. It was on a very short gap that the semi and the final started, but we ultimately had to conclude it on Sunday because we cannot ask Honorable Lordship's time for any other day apart from Sunday.
It was indeed fun to argue at 12 at night. So thanks for that.
All right, so you were there in Samir sir's courtroom, right?
No, we ended around 11 something, 11:40, 50.
No,
we were in
then
the courtroom too.
There was one courtroom number 1 which was going on till 1 o'clock, 1:30.
Yeah, right. Yeah, that's
Yes,
what kept us up all night.
They were in Anurag sir's court.
They were in Anurag sir's court. All right. So now I think they know how difficult it was for us. Like every other court ended at a different time, and we had to rush to every team, every other judge to ask for the marks. We had no idea when one would end, what judges, how much time judges will take. So
We have fixed a time of like 20 minutes per team, but the judges don't listen for 20 minutes per se. They just want to listen.
Even the judges of organizing committee don't listen.
Are we allowed to leave now?
Yeah, sure.
Oh, okay.
When is
You will all will be again be joining the same link, same room. Okay.
Just you have to text us in the WhatsApp group when we have to join.
Yeah, definitely.
Yeah, you just have to wait for a few minutes. I will ask his lordship to give some marks. He actually is tired. I just can't go and ask him again to write something. I'll just let him rest for a few minutes, maybe 10-15 minutes. Then I'll go and ask him for the mark sheet. All right. Thank you. Thank you, guys.
Thank you for your time.
Everyone, thank you.
Congratulations.